That home is building. That's kind of the building.
Yeah, it was like present. Oh yeah, it was funny. All six. I did. I get work out of it. Can't really sit. Okay. And then it will like spark.
I will help you with it.
How we doing? It was strip there. Okay. People are just. Yeah. Maybe the other. Yeah. Yeah. Oh, it's great. Yeah, I live next to the woods. Foxes, bobcat. Just think that.
Hey, you're fine.
You big figures. The one time where I had to report. I don't know. It's just-
So, you know, it makes sense.
Have funds for land order.
Is it not what you-
Thanks for.
Yeah.
Yeah.
Sounds good. That's probably some.
Right, the application.
Yeah. Pull back. Yeah. Leave Friday, it's just Saturday, Sunday, Monday, just Tuesday. So I gotta come back and then shop.
I know.
Yeah, this was it.
Well, we got it.
Thing. Because it stays there. Sure. They don't make it like.
Yeah. We're due for a week of rain. You might get that Sunday.
Good morning, everybody. My name is Vice Chairman David Arconti, and Commissioner Karen is watching via YouTube channel, just as FYI to everybody. Today, we'll be hearing oral arguments with respect to the proposed final decision in docket number 24-1201, the application of the Yankee Gas Services Companies to amend its rate schedules. So we will do 2 rounds for oral arguments, and we'll take the first round and then allow for some rebuttal in round 2. So we'll take appearances first. So any attorney representing a party intervener who intends to participate in oral arguments this morning, please approach the microphone and state your name and the party on behalf of whom you'll be presenting argument to for.
Good morning, Vice Chairman, and good morning, Commissioner Karen, who's watching remotely. Vincent Pace for Yankee Gas Services Company, doing business as Eversource Energy, and I'm joined today by Attorney Tiffany Tisler and Eric Eggleston in the audience. Thank you.
Morning, Vice Chair Arconti, Allison McCorney for the Office of Consumer Counsel. I'm joined today by Attorney Kimberly White and Consumer Counsel Claire Coleman.
Good morning, Vice Chair Arconti. My name is Caroline McCormick on behalf of the Office of the Attorney General, and I'm joined here with my colleague, Assistant Attorney General John Wright.
Good morning, Vice Chair Arconti. Tom Lopez on behalf of the Office of Education, Outreach, and Enforcement, and I'm joined by my colleagues, Attorneys Alex Sahi and Brittany Wyman. Thank you.
Okay. Is that it? Looks like it. Okay. So before we get started, I'm going to present the same opportunity as a couple weeks ago in the UI oral argument case. Just want to take a pause and ask the stakeholders if there are recommendations, thoughts on if we would like some more process in the case, considering all the events that have transpired over the last couple weeks. So I'll take a pause there and let some folks approach the microphone.
Thank you for the chance to respond to that very important question. Yankee fully supports any type of constructive discussions offline between the parties to achieve a consensus resolution. We think that in light of all the concerns we've raised in our written exceptions and the presence of bias in this case, the only constructive path forward is to try and achieve a negotiated compromise. And we're ready, willing, and able to participate in those discussions. But I'd like to hear from the other parties. Thank you.
OCC?
Sure. Good morning, Commissioner Arconti, Claire Coleman, Consumer Counsel for the Office of Consumer Counsel. And good morning, Commissioner Karen. Thank you for the opportunity to raise this issue. While we always have an open door policy at the OCC, we don't object to conferring directly with parties. We do think there are some specific challenges in this case that are present that were not present in the UI rate case and the ability to engage in settlement discussions there. First, while we embrace consensus resolutions and the opportunity to be collaborative, that should not be construed as conceding any of the bias or other substantive points that the company is putting forward with respect to why a settlement might be necessary. We do understand the benefit of applying your resources, your team's resources, and all of the resources here in the room in the most efficient way. And that is our concern. We do think oral argument should proceed this morning, given that the authority could finalize a final decision that could cure any of the issues raised by the company. So as a starting point, we think oral arguments should proceed, and the authority should not preclude the option of finalizing the decision. In terms of a consensus resolution, there are specific statutory factors here that were not present in UI. Specifically, I want to call the authority's attention to 1619 JJE2, which was amended in 2023 by Public Act 23-0102. And specifically, it states that any proceeding to amend rates under 1619 that is resolved by a settlement shall not constitute a general rate hearing for purposes of the periodic review required under Section 1619A if the previous proceeding to amend rates under Section 1619 was resolved by a settlement in full or in part. Now here, given that the last Yankee rate case, which was 1805-10, was settled, we read that statute to say any settlement would have to be immediately followed by either another rate application or a 4-year financial review, which our concern is would render all of the work done over the last year basically for naught. We took this position in CNG-SCG when we engaged in settlement negotiations, and as part of that, we reviewed all of the statutory guidelines and came to the conclusion that it wouldn't be in ratepayers' interest to throw away a year's worth of work. And we feel that we have the same statutory constraints here. If the company or the authority reads this differently and thinks we can achieve a more efficient result with a settlement, then our analysis has landed. We welcome counter perspectives, but at this point, given these statutory constraints, we think it's appropriate to proceed with argument this morning.
Thank you, Claire Coleman. AG's office?
Thank you. Similar to the Office of Consumer Counsel, our door is always open, but we'd like to echo the comments of Consumer Counsel.
Okay, thank you. Attorney Pace.
So I expected we would hear that concern, and I appreciate the fact that it was raised in good faith because understandably, I agree with the Consumer Counsel. We want to make sure whatever path we take is a solid path, we're on solid footing to actually proceed forward. And I think we have to start with the words of the statute. And the Consumer Counsel correctly points out the statute is 16-19JJ. I did, in advance of this proceeding, provide to Ms. Lupoli a copy of the statute. I'd like to have it shown on the monitor so we can actually see what the words say, because the words are very important. So if I could ask Ms. Lupoli to please call up General Statute 16-19JJ, and then when that's on the screen, if we could please scroll down to Section 2 at the very bottom, which I highlighted. So that's a copy of the statute from Westlaw. And the only change I've made is I've actually put in highlights subsection E2. And as Consumer Counsel Coleman pointed out correctly, this was amended in 2023 by Public Act 23-102, Section 4. And what it says is in any proceeding to amend rates under Section 1619 that is resolved by a settlement shall not constitute a general rate hearing for purposes of the periodic review required under Section 1619A. If the previous proceeding to amend rates under Section 1619 was resolved by a settlement in full or in part. So we concede that Yankee's last rate case in docket 180510 was resolved by a settlement. But there's no language here that says it bars two settlements in a row. All it says is that if you had your last rate case resolved by a settlement, then a second settlement is not a general rate hearing for the purpose of the review under 1619A. So the natural question is we need to now turn to 1619A and see what that says. So if I could ask Ms. Lupoli, I did provide her with a copy of that statute. If we could please turn to that. And once again, this is a printout from Westlaw. The only change I've made is to put some yellow highlights to facilitate our review. If we start with Section A1 at the very top, it says the Public Utilities Regulatory Authority shall, at intervals of not more than 4 years from the last previous general rate hearing of each gas company, electric distribution company, or water company, having more than 75,000 customers, conduct a complete review and investigation of the financial and operating records of each such company and hold a public hearing to determine whether the rates of each such company are unreasonably discriminatory or more or less than just, reasonable, and adequate. So if we pause there, what I said was important because it doesn't say you have to have a rate case every 4 years. And it also doesn't say you need to have a general rate hearing every 4 years. What it says is large public service companies like Yankee Gas need to have a review and investigation. If we move down now to subsection A2, which is highlighted, that first sentence is important. It says the authority may conduct a general rate hearing in accordance with subsection A of section 1619, which is the rate case statute, in lieu of the periodic review and investigation proceedings required under subdivision 1 of the subsection. So what does that mean? That means that we have the mandatory obligation for large public service companies to have a rate review and investigation every 4 years. That's the requirement of Section A1. Section A2 says, in lieu of conducting that review, you can also have a rate case. So how do we move forward? How do we ensure that if we enter into a settlement that's approved by the authority, we can comply with these two statutes? Yankee's recommendation is if we reach a consensus resolution and that's approved by the authority, we comply with the statute because the settlement can say the parties stipulate and agree that for the purposes of Section 1619A1, this docket over the past 11 months, with all the hearings and all the evidence and all the investigations, constitutes a review and investigation of the company's records. You did hold a public hearing, and you determined whether or not the rates were unreasonable and discriminatory. That would be the path forward. Another important point to think about is the concern I'm hearing from parties is, did we have some type of open and transparent process? And we did. We don't need to look at legislative intent because the language is clear on its face. General Statute 1-2Z, the plain meaning rule, says there's no need to resort to any type of legislative history or other sources when the language is so clear. But if we try and think, why was the statute amended in 2023? One potential reason may be they wanted to ensure that there's transparency. And we've had significant transparency in this proceeding. We filed the application on November 12th, 2024. For the past 11 months, we've built a substantial record. We've had two public comment hearing sessions. We've had multiple hearings with cross-examination, a very substantial record. The authority, DEEP, OCC, and other parties looked at all of our books and records. We had 2 on-site audits. This is a clear example of transparency and accountability, and we have that record to back us up. So this interpretation of the statute provides a reasonable path forward to allow the parties through consensus to resolve a situation where, whether we like it or not, this draft is tainted by the chairperson's bias. And the only way, in our view, is to resolve it under 2 ways. The first would be a consensus resolution. The second would be we take an appeal, and that's not a constructive approach. That's a time-consuming approach, and the relief we're awarded is retroactive back to the date of October 28th, 2025. That is not in the interest of ratepayers. We do not want to have to pursue that option, but if a settlement is not possible, that's the only option available to this company. I'd be happy to take any questions about our interpretation of these 2 general statutes.
No, I suppose I do want to ask a question, but I think the other parties would be the ones to address it. But so I guess the question I'll pose is, there is a robust record in this proceeding. So one read of the statute could be to not necessarily prevent, but discourage, quote, black box settlements. So I'd like to I'm happy to take your response to that, and also would love to hear from the AG's office and OCC, but also also maybe get everybody's thoughts on, in the first part of the statute, where it says the Public Utilities Regulatory Authority may, whenever it deems appropriate.
And so just to clarify, very good question, Vice Chairman Arconti. And just to be clear, if I could ask Ms. Lupoli to please turn back to 16-19JJ, because I understand the Commissioner's question to be, you'd like the party's reaction to subsection A of 16-19JJ, correct?
Correct.
So if we can scroll up to the very top of that statute, Vice Chairman Arconti correctly points out that it says, and I quote, "Pura may, whenever it deems appropriate and is consistent with the principles set forth in Section 1619 and 1619E, adopt proposed settlements produced by alternative dispute resolution mechanisms to resolve contested cases and proceedings." The benefit of our interpretation is that we're interpreting this statute and 1619A to affect the intent and the actual words you see there. Our interpretation allows PURA, when it deems appropriate in this contested case, to approve a settlement based on the significant circumstances presented here of bias and many errors in the draft decision. And the concern would be that if we read these statutes to say you're barred from approving a settlement, then that's inconsistent with subsection A. Subsection A says that you may, when you deem appropriate and consistent with the principles in 1619 and 1619E, adopt the settlement. If we read these statutes to say you're not allowed to approve a settlement in this case, that's inconsistent with subsection A. And a very important principle of statutory instruction is that statutes need to be read in harmony so that all provisions are workable. We can't recommend an interpretation that negates or undercuts this language in subsection A. Our interpretation makes the statutes consistent. It doesn't negate any language, and it effectuates the actual words on the page by allowing you to exercise the authority given to PURA to approve a settlement based on the record in this case.
So maybe a simpler question is, on top of the first two I posed, does any party take the position that a settlement is barred in this case?
We
So-
do not, but I'm
yeah,
happy to hear
yeah,
from the others.
Thank you, Commissioner Conti, for the opportunity to respond. I think we agree with Attorney Pace's construction of 1619 JJ, except for the fact that we don't read this as allowing for this type of stipulation he suggests. You know, we've now read the language to you twice, so I don't want to repeat it again. But it says that you cannot resolve, you know, a settlement shall not constitute a general rate hearing for purposes of the periodic review under section 1619A. So standing here at this moment, we don't believe that any stipulation in a settlement could waive that statutory requirement for the authority. So while it doesn't explicitly bar a settlement approval, it renders it at a minimum inefficient because the authority would have to immediately start that periodic review. I do agree with Attorney Pace's read of 1619A that it's a 4-year review, or the authority may do a full rate case. But you know, we're just not sure what that 4-year review looks like and how it could be anything, you know, in terms of the process required. It still feels like it would be a time-consuming and expensive process for all sides, and we don't want to waste ratepayer funds by conducting 2 similar proceedings back to back. That's our concern. Thank you.
I'd like to just get to the AG's office and we'll circle back. Attorney Pace, thanks.
Thank you, Vice Chair Conti. I think it's appropriate to say our position is very similar to the Consumer Council. We think the statute speaks for itself. It's clearly a remedial statute. Somebody in the legislature or persons and interest groups thought that settlements were not allowing the authority to have the same degree of control and management over the company's expenses and charges. as a remedial statute, we think it's to be read broadly, and that is how a court would interpret that. We, again, are always open to settlement agreements, discussions with the company, and we're not opposed to that. On the other hand, there's a very high bar here. The company has brought a number of complaints against a draft decision that has taken months and months of hearings and interrogatories and data requests. The authority has had a full and complete opportunity to conduct a hearing to determine appropriate, just, and reasonable rates. We think the authority has done so here. There are risks of litigation, as the company has raised multiple points in this, and there will be risks in litigation if there is a settlement that is produced that appears to go against what the statute says. I don't know, this has not been reviewed before, but we would caution you before saying a settlement agreement here would fly through review, appellate review, without a problem. We only want to make sure that the authority understands that before directing the parties to settle. Thank you.
Thank you, AG's office. Companies to respond?
So this dialogue has been helpful, and I appreciate the fact that everybody has the shared goal of trying to make sure we get this right. But I want to focus on a very important sentence that Consumer Counsel Coleman made when she said, "My concern would be that if we move forward with a settlement, then we have to spend time and resources conducting the review and investigation required under 1619A, subsection A1. But I respectfully disagree for a very important reason. Think about what we've done in this docket over the past 11 months, the record we've built, the questions that were asked, the review that took place. What would you do in addition to what you've done over the past 11 months if you had to convene a separate review and investigation? And the answer I pose is there's nothing additional you can do. You've had close to 2,000 interrogatories. You've had 2 on-site audits. You've looked at all the company's relevant books and records. So my view would be the record in this docket is sufficient for the parties to stipulate that it satisfies the requirement of also being a review and investigation. Because again, I put it to the parties. They're saying that if you approve a settlement, then you must conduct a separate review and investigation. But for what reason? What else would you do? There is nothing else to look at because this record is so exhaustive, the review is so probing, and the parties can very readily stipulate that this exhaustive review in this docket meets the requirements for the review and investigation of financial and operating records. There was a public hearing and an examination of whether or not rates are just and reasonable. The statute doesn't require that that be done. The parties can stipulate it has been satisfied in the record in this docket. Thank you, Vice Chairman.
Okay. So oh, thank you for giving me more time to think. OCC Council, OCC.
Great, thank you. Just to round out the discussion, we are still admittedly concerned about the proposal to have the authority constitute this current rate case as a periodic review under 1619A, when it seems that the intent of that 1619 JJ2 was to say the opposite, that you can't count it because we want to, and as far as your question about legislative intent, as I recall, there was a lot of discussion around, transparency and black box settlements, which I would agree with all the process here does not apply. But I also believe there was some concern about successive settlements, 2 in a row. And that's maybe, I was just trying to find the language in the legislative intent. I did not find the specific wording, but I would refer the commission to both the public hearing transcript from February 14th 2023 on SB 7, as well as the public hearing on February 22nd, 2023, which was then SB 123, where the same issue was debated, as well as House floor remarks on SB 7, Section 4, on June 5th, 2023, that can help provide a deep dive on the legislative intent. And Attorney Minikowski may have. Okay, and Attorney Minikowski, sorry, not, sorry, McCorney, sorry, is pointing us to the bill analysis by the Office of Legislative Research on Section 4 of SB 7, which says it sets procedures and conditions for PURA to approve a settlement in a rate amendment proceeding, allows PURA to reject or modify a settlement provision that extends longer than an approved rate amendment, and limits the extent to which a settlement may be used to satisfy the law's requirement for companies to have a rate case at least once every 4 years. So hopefully that legislative context can provide the commission with additional information. I realize this is a lot to unpack, so I might respectfully suggest that we proceed with oral argument. We'd welcome feedback and direction from the authority on these points, because again, part of a driving component of our concern is the efficiency of resources, and certainly I can see the authority staff and commission also being reluctant to have to initiate a 4-year review immediately after a settlement. So would welcome direction and feedback from you as you evaluate this further. And I think we can proceed with the substantive arguments so that the authority is still on track to issue a final decision at the end of October. Thank you.
Attorney Pace.
So I agree. I'm happy to proceed with arguments on the merits. I would just point out there's been a focus this morning on the topic of efficiency. And I would posit that when we talk about efficiency, is it more efficient to use the time that we have to focus on a constructive path forward that's a fair balance of the needs of customers and the company, or to spend another year litigating a rate case to have it sent back to cure an issue of bias and putting customers on the hook for relief retroactive to October 28th of 2025. But I would like to proceed with oral argument if that's acceptable to the Vice Chairman.
Yeah, I like more time to chew this over. So if you don't mind, let's proceed with oral argument, and then I can circle back at the end of the hearing with maybe some guidance on next steps forwards, because this is, again, a lot to unpack, and it's a limited calendar. It's just a lot right now. So Attorney Pace, if you're ready to proceed, feel free to begin.
I am. Thank you very much, and I appreciate the opportunity. And I neglected to say good morning to the authority staff and good morning to the parties and the interveners. I want to thank them on behalf of my client, Yankee Gas, for all the hard work they put into this case. We appreciate that very much. As you know, by way of background, it's been 7 years since the company's last rate case in 2018. We proposed and supported a rate increase of $193 million, but the draft only granted 20% of that amount. It's undisputably slanted against the company because there were 133 line items in the company's revenue requirement. And out of those 133, we had cuts in 111 of them. The bulk of the disallowances and penalties are created by PURA. They weren't introduced or recommended by the parties or interveners. I always try to be an optimist. I always try to find something constructive or positive to say, but I can't do that today because there's nothing constructive I can say about this draft decision. Our exceptions demonstrate the draft is unjust, it's unreasonable, it doesn't fairly balance the needs of Yankee Gas and our customers, and most regrettably, it's the product of prejudgment and bias. Our exceptions also pointed out that we submitted 2 motions asking for more time, We only received 9 business days to respond to a 200-plus page draft decision. We did our best. We filed over 200 pages of written exceptions, but there are still errors and hidden issues we're trying to work through, and we reserve the right to supplement our filing. Our exceptions also demonstrate that the draft decision is going to cause Yankee to fail both Moody's and S&P's credit rating metrics. And when we took the numbers in the draft decision, what they showed us was, if this stays the way it is, right after the rate effective date, Yankee's earned ROE would be 5.36%. That's on day one after rates take effect. That means we're setting up Yankee Gas for another potential credit downgrade, and also we'll have to file another rate case as soon as we can to try and undo the damage caused by this draft decision. You see here in the audience today, there's an overwhelming showing by Yankee Gas and Eversource, including our president, Kevin Kelly. They're here today because, as an attorney, there's no words I can offer to really communicate how frustrated and disappointed they are with this draft decision. But there is something the 2 commissioners can do to help us start to turn the corner and move in a more positive direction. And that is, at the end of today's hearing, if you can signal to us you are open to having us negotiate in good faith and present for your consideration a consensus resolution. We support that approach. We pledge to be constructive. We pledge to be fair. We pledge to be balanced, because we understand it can't all be one-sided. What we're asking for is something that's reasonable and something that's equitable. I'd like to make 2 points today. The first point is there's several due process violations, including bias, that warrant discussion. And second, there were many, many legal, factual, and math errors in this draft decision. I'm not going to go through all of them out of respect for your time because you've read the written exceptions, but I do want to highlight 7 of them very quickly just to illustrate the significant errors and problems in this draft decision. So I'll first start with the due process violations. I know this is a very difficult topic, but we have to confront it, and that is, when we filed on June 10th, we filed a motion for recusal based on bias, and we supplemented that motion. Due process says Yankee Gas is entitled to impartial decision makers, and our June 10th motion demonstrates that there's been bias in this proceeding. The January 21st procedural order said the chairman was the presiding officer in this case. And in our motion, we cited to the fact that in the SCG rate case, motion ruling number 118, docket 231102, the authority said all evidentiary and intermediate rulings in a contested case, that includes the draft decision, those are made by the presiding officer. And our presiding officer in this case was Chairman Gillette. So this draft decision is the work product of that presiding officer, produced under her supervision and control. And it's impacted by bias. That bias can't be cured by a recusal. That's only one step in the right direction, but it doesn't cure it. And that's evidenced by the fact that in the present C&G SCG rate case appeal before Judge Budzik, it's very clear the Peers Council has said a potential solution is to remand it back to this agency for a brand new set of hearings and a brand new decision without Chair Gillette sitting on the bench. And if we continue to go down this path in this docket, and there isn't a consensus resolution, we're setting ourselves up for the same type of appeal, an appeal that says there's numerous errors of law and fact, including the due process violation of bias, which results in more litigation, more delay, and coming back here to restart the hearing process. So the only practical remedy in this situation is a consensus resolution. Also, as I said before, a settlement shields customers from having to pay out relief that goes back retroactive to the rate effective date. What I point to for that proposition is when we had Aquarion's motion to stay PURA's 2023 rate case order, in the Attorney General's brief from April 26, 2023, they said the prohibition on retroactive rate making does not bar a court that's reviewing an appeal from ordering those types of remedies. So do we want to put customers in a situation where we have to take an appeal come back here and do things over, and the relief is retroactive to October 28th, 2025. That is not in the best interest of customers. The second due process violation we identified was we filed on September 5th, 2025, motion number 127. What that motion said was we need additional time to respond to the draft decision. That was not the first time we raised the issue, and it was denied. Almost a year ago, on November 29th, 2024, in motion number 12, when we first saw the schedule, we said 9 business days is not enough. We asked for more time, and the answer was no. So we did our best to identify the errors that we saw, but as I said before, we reserve the right to identify additional ones as they become evident to us. And the third due process violation is we filed on September 26th, motion number 130, which asked for the staff's work papers. We did not receive those work papers before we filed our written exceptions. So due process requires in this contested case that we have a chance to review and to cross-examine and rebut evidence. We concede the authority staff has the power to summarize and analyze record evidence. That's established by the Connecticut Supreme Court's decision at 183 Connecticut 128 from 1981. But what the staff cannot do is create their own brand new evidence. They also can't create brand new calculations no one's ever seen. We have a right in this docket to understand how those calculations were achieved. We are not able to replicate them. We can't produce them. And so our view is that's brand new evidence that we should have access to the work papers to understand how did you get from point A to point B. It wasn't based on our evidence. It wasn't based on the OCC's evidence. So there's some other evidence being used to generate the calculations. We need to understand what they are and to see the work papers to determine if we need to cross-examine or submit rebuttal testimony in response to the new evidence. I'm now going to move on to the second part of my presentation, which is to talk about the errors in the draft decision. As I said before, out of respect for your time and Commissioner's Karen time, I'm not going to walk through 200 pages of written exceptions, but I do think it's important for me to illustrate some examples. And I just picked out 7 to give you a sense for how tainted and how wrong the draft decision is. I'm going to first start with the math errors. On pages 180 to 183 of our exceptions, we point out there's a math error totaling $4.7 million for the computation of gross earnings tax. On pages 119 to 122, we identify a $7 million math error in the calculation of payroll. On pages 163 to 166, we identify a $3.2 million calculation error for environmental remediation. And I'll point out, in our view, a court will not defer to PURA on math errors, as evidenced by Judge Budzik's March 24th, 2024 decision in the Aquarion rate case appeal, where PURA had to concede a math error, and it was directed back here to correct the math error in the calculation of taxes. The second error I'd like to focus on, and this one is very significant, it's referred to as the cost of removal. This was a $101 million disallowance in the rate case. It appears at pages 56 through 72 of our exceptions. The cost of removal is essentially the cost of retiring or removing gas plant, including the cost of transport and to handle. So if you think about the type of work my clients do, they fall into 2 categories when we talk about capital work. First, there's new construction, putting brand new pipe in the ground. So think about a situation where a customer or a neighborhood was using propane or oil to heat, and we put in brand new infrastructure. There's no cost of removal in that situation because we're putting in brand new infrastructure. But then think about all the good work my clients are doing to replace bare steel and older infrastructure. In those situations, you're retiring and you're removing some infrastructure. That's the category of cost of removal. And the record shows you cost of removal has been going up for 2 reasons. The first is we're doing what you told us to do. We're replacing that old infrastructure to make it safer for customers. The second reason is there's less new service jobs. Less customers compared to historical are asking for new service to be installed. But for some unknown reason, page 29 of the draft says you're disallowing $101 million for core. Why is that a problem? Well, it's a problem for many reasons. First of all, that's an illegal reduction to rate base because there was no finding of imprudence. There was no application of a prudence standard. There was no conclusion that that was imprudent. The authority simply concludes with the swipe of a pen, we're going to remove from rate base $101 million of cost of removal. And what's important also is we explained to the authority in late file exhibit 105 that these types of capital work fall into one of two categories. It's either going to be cost of removal or it's going to be plant and service. And you can't just remove it from core and then not put it back into plant and service. So with the swipe of a pen, with no finding of imprudence, the authority says we're pulling out $101 million from your rate base. There was no other party or intervener who advocated for this. This was something that the authority thought up as an opportunity to reduce the amount of the company's rate relief. But again, no application of a prudence standard, no finding of imprudence, and there's no recognition if it's not core, then it's going to be plant and service. What also is concerning to us is when you look at the last 5 rate case decisions issued by the authority, that's for Connecticut Water Company, the last 2 UI rate case decisions, the CNG and SCG rate case decisions, there was no disallowance for cost of removal. So the concern that we have is we're dealing with ever-changing standards. It also demonstrates to us there appears to be one standard for Eversource and another standard for other companies. And the concern that we have with that is not only is that illegal, but more importantly, it's very difficult to run and plan a utility business. So what we're looking for is some type of consistency, some type of predictability when we put these rate case applications together. We carefully read all the authority's rate case decisions, and we learn and we adjust from those rate case decisions. But we also develop expectations that when we come in front of you, we'll be treated in a consistent and fair manner in the same way that other utilities were treated. And it's very disruptive to our planning to have the authority keep changing the standards, to keep moving the goalpost. There's no way for us to have any sense of reasonable predictability when we keep making changes like this. The third concern that we raised in our exceptions was there was a very significant disallowance to utility plant and service. $37 million, it's described at pages 44 to 49. So by way of background, we filed this application on November 12th of 2024, and the disallowed infrastructure investments that are completed capital plant additions were from the period January 2024 to May 2025. Now the draft says we're going to disallow that for 2 reasons. The first is it says, Yankee Gas, we looked at your application. You never raised this issue in the application. The second reason it gives is it says you failed to ask for an amendment within 30 days of when you filed the application. But the problem is both those statements are false, and here's why. First of all, our application very clearly says Yankee Gas Revenue Requirements 1, pre-file testimony of witnesses Peruta and others at pages 16 through 18, we provided a forecast of the plant additions during that time period. We actually gave a table on those pages that showed what we projected them to be. But also more importantly, for transparency purposes, pages 16 to 18 say, as the case progresses, we will update you on the actual completed infrastructure investments. So we weren't hiding the ball there. We said that from the get-go in the actual pre-file testimony of the application. And we also provided in the capital panel pre-file testimony in the original application at page 93, table 9, a forecast of plant additions for 2024, 2025, 2026, and beyond. So the first statement in the draft that we failed to raise it in the application is false for those reasons. Now, the second justification the draft offers is it says you failed to ask for an amendment within 30 days of filing the application. And it cites to Authority Regulation 16-158. But if we actually look at the words of that regulation, it doesn't apply here. What that regulation says is, if an applicant seeks to increase the revenue requirement or increase the rate you propose to charge, then you have to seek permission for an amendment. But we didn't increase the revenue requirement. We didn't increase the amount of rates we're looking to recover. The original application asked for a revenue requirement for new rates of $209 million. When the case was concluded, we dropped that down to $193 million. We have never asked to increase the revenue requirements or the rates compared to the original application. So that regulation has no effect. What's also concerning to us is, here again, we have a disallowance of plant additions. There's no application of a prudence standard. There's no finding of imprudence. And so case law is very clear. For the authority to disallow plant additions, you need to apply a prudence standard. You need to actually find imprudence, and then you can disallow plant additions. But there was no finding, and there was no application of that standard in this case. My fourth error I'd like to talk about is depreciation, and that appears at written exceptions, pages 175 to 179. This was a reduction of $34.3 million, and it was above and beyond what any other party recommended in the case. Now, Pura's calculations, my clients have said to me, are not supported by the record. They cannot understand how Pura reached the conclusion that it did, and we can't replicate or confirm those calculations. We had no opportunity to cross-examine or rebut any work papers the authority relied upon to reach its own calculations. And also, and this is very troubling for the company, if we don't know how to calculate depreciation, we're not able to book the depreciation expense. So we need to understand how were those numbers derived, and so how can they actually be implemented? The only way to clean that up and to resolve it, in our view, is to implement the depreciation numbers that we offered, because they are credible, they are supported by an expert, and they're reasonable under the circumstances. The fifth error, and this one is very significant, is on the issue of hardship uncollectibles. And that appears at written exceptions, pages 139 to 154, and that was $2.7 million. That's a $2.7 million immediate write-off, but the damage doesn't stop there, because the way the authority drafted this will keep sustaining damage year after year, and here's why. First, let me ground everyone to say that uncollectibles are essentially the unpaid bills from our hardship customers. And what's important here is we don't really control that number. It's driven by actions of the state of Connecticut and direction by Pura. The biggest drivers that impact the amount of hardship bad debt are Pura's COVID-19 shutoff moratorium, the terms you order us to follow every year as it relates to debt forgiveness and payment plans and debt collection practices, and probably the most significant factor is Pura ordering the companies to follow the Department of Social Services classification for who is considered hardship. If DSS confirms your hardship, then you qualify as hardship for debt forgiveness. And that's been a huge driver in the increase for the amount of the uncollectible hardship bad debt. And the historical approach has been, we're allowed a certain amount in rates, but if as a result of these state programs, the cost goes up, we can defer it. And we're not asking for a blank check. The approach has always been defer to the next rate case, subject to a full prudence review. But the draft decision makes two significant errors. The first is, it says for purpose of setting rates, we're not going to look at the most recent information. We're going to take a 7-year average and include some stale historical information that doesn't reflect all the new policies that Pura has implemented in this area. And that results in artificially depressing the amount we recover in rates. But the damage doesn't stop there. The authority goes on to say, when you implement these state programs, if you incur any money in excess of what's in rates, it's a shareholder expense. So we've never seen that treatment before. And the other concern we have with that is, again, we're talking about inconsistent treatment. When I looked at the CNG and SCG rate case decision that came out 11 months ago in docket 23-1102, what it says is CNG and SCG are allowed to defer to their next rate case over and under collections for hardship, but not Yankee Gas. There's no principled reason or legal reason given to do that. The authority is just saying, we're changing our standards. And the shareholders have to bear the loss if a state mandated program goes above and beyond what's in rates. It's also an error of law because the statute that we cite, 16-262C, says we are allowed to recover the costs for these payment programs, this arrearage forgiveness, as long as we can demonstrate we were prudent, as long as there are no violation of statute or regulation. There's no finding of imprudence. There's no violation of a statute or regulation. This is a policy decision by the authority to basically say we're going to be punishing you because we want to change the rules, yet once again, we want to be difficult with Eversource. So the request we have is treat us the same way as CNG and SCG. Give us the opportunity to continue to run these state programs, and if the cost exceeds what's in rates, we will come back here in the next rate case and hold us accountable. We have to demonstrate we were prudent. We're willing to do that, but this should not be a situation where we simply have to write that off as a shareholder expense because a state mandated program exceeds the artificially low amount that's in base rates. I have two more, and I appreciate your patience, and I'm just going to move through these as quickly as I can. But I wanted to give the Vice Chairman and Commissioner Karen a sampling of different areas in the exceptions where it's permeated with problems. The next area is environmental remediation. That appears at pages 163 to 171 of our exceptions. It's an immediate $3.2 million calculation error, but the damage keeps recurring year after year unless we fix this. So we're talking about 14 manufactured gas sites where we clean up those sites in compliance with state law. There's no claim and there's no evidence that somehow we're not following the law. In fact, what the record shows is we're being a good corporate citizen. We're partnering with DOT, many towns like Shelton, Wallingford, Waterbury, Meriden, and others to be responsible and to implement remediation in a constructive and reasonable way and also addressing their needs. But the first problem is the math error. We talked about that. The second problem, which is more significant, is it says if you spend $1 more than we're allowing in rates, that's a shareholder expense. The law requires these sites to be cleaned up. The record shows we're doing a very good job. The record also shows no matter how hard you plan and prepare, there's going to be situations that come up in the field that will require you to respond and maybe incur additional dollars. One example we offered in the record was when we were cleaning up the Waterbury MGP site, the DOT came to us and said, you need to speed up your schedule. We want to do construction work on the Mixmaster highway system we have in Waterbury, and we accommodated that. But to speed that up, we had to spend extra dollars, but we did so in the most cost-effective way that we could, and we accommodated the Connecticut DOT. What this decision says is when DOT or towns come to you in the future and say, can you work with us? Can you make some adjustments? Our response is going to be no, because PURA said you have a fixed budget, and if you go beyond that every year, you're not allowed to recover that in rates. So the proposal we ask you to consider is, once again, one that you granted for another gas company, but you're not giving to us. In the SCG rate case in 23-1102, you said SCG could defer the difference between its actual Chapel Street environmental remediation expenses and the amount allowed in rates. And at the next rate case, and we're willing to do that, we have to demonstrate to you any amounts we spend beyond what's in rates were prudently incurred. So why do we have another situation here where one gas company, SCG, is getting permission to defer, but Yankee Gas is not receiving that permission? And so what we ask, therefore, is to be treated consistently, to be treated fairly, to recognize this is a legal obligation. There's an important public policy in cleaning up these dirty sites. And if we exceed the amount in base rates, we have to prove we were prudent, and we can defer to the next rate case. Also, we admit, if we underspend, that money goes back to customers with interest. So we want to be balanced. The final error that I want to talk about is something near and dear to my heart, which is legal expense. Talked about at pages 158 to 161 of our exceptions. We had a test year expense of $627,000. For the rate year, we said we want to reduce that to $467,000. Why did we do that? Because we said there were certain expenses we incurred in the test year which would not be repeating. So on our own volition, we lowered it to a lower amount in the rate year. And the rationale that PURA gave was it said it's not convinced that a company as large as Yankee Gas will have even $1 of outside legal expense in the rate year and every year thereafter. Now, the record shows that we keep our in-house counsel, including me, very busy, but we use outside counsel in situations where we don't have the expertise or the time to get to something. And there's also many examples we gave in the record of where using outside counsel helps our customers. Here's just a few examples. When municipalities increase the property taxes that customers have to pay, we hire outside counsel to file appeals. The goal there is to reduce the amount we're paying in property taxes, which benefits the ratepayer. We also, when we're allowed to proceed with debt collection, we use outside counsel to help moderate the impact of uncollectible bad debt on all of our customers. And another area we showed in the record was we are subject to rates that are charged by interstate pipelines who deliver that gas to Connecticut. We hired outside counsel in a FERC proceeding where one of our interstate carriers sought to increase rates. By using outside counsel, we're able to try and push to reduce those rates for interstate transportation that are passed along to our gas customers here in Connecticut. So the draft's conclusion that a company as large as Yankee Gas should not be expected to spend $1 for legal expense in the rate year is unreasonable. It's not supported by the record. What I'll also point out, and here we have it again, is we're being treated differently than other companies. If we look at the UI draft decision in 24-1004 at page 119, you authorize UI to recover $337,000 in rate year legal expense for outside counsel. In your SCG final decision from docket 23-1102, you allowed that gas company at page 101 to recover $207,000 for outside legal fees. So the concern again here is, and the draft decision says this in black and white, we have one set of standards for Yankee Gas, different standard for other utility companies. The last concern I'll point about this is that you're sending us the wrong message. If you say to us you can't use any outside counsel, we're not going to fund any of that, then what you're saying to the company is hire more in-house attorneys. And that deprives me the flexibility to be able to use a contractor who can pivot in for specific work, and when that work is done, we don't have to keep them on the payroll. That allows us to be much more efficient and much more focused. We have the core staff we need to do our day-to-day work, and when we have these special matters, these unique cases where I need outside expertise, I can bring in the contractor, have them do the work, and then end the relationship because it's no longer needed. That concludes my oral argument. I want to end by noting that over the course of my career working in front of PURA, I've gotten to know many PURA staff members. And of the staff members I know, I find them to be very hardworking and responsible men and women who take their jobs very seriously. They do their homework, and they try to recommend outcomes based on the law and the facts. So when we see a draft decision like this, it's unfortunate because I can't separate out the good work done by the PURA staff and the bias and prejudgment that was shown by the chairperson. My hope here today, and by being so direct with you, is that we can all start to turn a corner and move towards more constructive and more balanced and more predictable outcomes. And so that's why I'm asking at the conclusion of today's oral argument, if we could hear from Commissioner Karen and also Vice Chairman Arconti, if you'd be open to having the parties negotiate in good faith and present to you a balanced and a constructive negotiated resolution. So I want to thank you for the latitude. It was important for me to put that into the record, and I'm happy to take any questions.
No questions right now in round one. Let's proceed to OCC.
Good morning again, Claire Coleman for the Office of Consumer Counsel. First, I do want to point out, going back to the issue of settlement, that I heard an inherent inconsistency in Attorney Pace's argument that PURA can rely on this process over the last year to satisfy the 1619A four-year review, but it can't be relied on to get to a final decision in this case because it's tainted with bias. Both simply can't be true. So I'll leave the commission to consider that. Again, we feel the bias arguments are overstated by the company, as Attorney Pace acknowledged a moment ago. We understand that a diverse range of experts within PURA work very hard to help put together a proposed final decision, and a final decision voted on by a commission that does not include Chair Gillette should have no concerns with bias. On the procedural arguments the company makes, I'm not going to go into each and every one of the motions in detail. Our office always promotes and encourages PURA to have the most transparent processes. I think it benefits all parties and consumers to have transparent processes and an extensive amount of process to be afforded to all parties. And that is generally what we've experienced here. I think that what is legally required is quite different than what the company's position is in support of several of their procedural motions. The UIPA doesn't even guarantee a draft decision at all or any process around it. So how can it be a UAPA violation to deny additional time and process? I think given the statutory framework would accept the company's application in full if PURA was not ready to issue a decision by the deadline without a waiver, those time constraints are real for the authority. And so balancing the right amount of process with deadlines, of course, is challenging. And we respect the necessity for PURA to make those decisions about the extent to which extra process is afforded. With respect to the due process concerns regarding PURA's math calculations with respect to its computations, again, we do support PURA decisions being as transparent as possible, and any explanations of how conclusions are arrived at are always helpful for the parties and for purposes of appeal. So in general, we support detailed decisions with lots of justification and rationale. But we don't believe that the authority is legally required in this case to produce its underlying calculations with respect to making final determinations on revenue requirements. And we don't think the cases that were cited by the company necessarily support that result. They were pretty different from the situation here. There were two cases, Palmisano and Carlson, which involve situations where commissioners use ex parte communications or evidence from non-parties to support their findings and refused, it was alleged they were refused to consider other integral reports that were admitted into the evidence. The other case cited in the company's brief, 17 Oaks, also makes clear that commissioners are not considered a party. So this is very different from receiving ex parte evidence or considering evidence not on the record from another source. And it also specifically noted a commission may rely on its personal knowledge when coming to a decision. So our understanding is, and certainly if, PURA knows best whether this is an accurate reflection of reading, but that PURA wasn't introducing new material, but using their own experience and expertise and knowledge to adjust and restate information that was already in the record, which we believe is permissible under the law. We do agree with the company that any math errors do need to be addressed to avoid appeal. We encourage the authority to ensure that the final decision is mathematically correct. And we do recognize the purpose of a draft decision and the benefit of having a proposed final decision, even though it's not required by the UIPA, is to allow all the parties to comment and raise issues and to help assist the authority and the staff to ensure that, any math or accounting errors are addressed. So we do encourage the authority to carefully review all of the issues raised and have confidence that they can be addressed sufficiently in a final decision. In terms of the application and the proposed final decision, I do think it's important to remind everyone that this, there were significant cuts in the proposed final decision, but this was also the largest rate increase request in Connecticut's history. Yankee has asked for an extremely high revenue contribution from customers, which would have resulted, if granted in full, approximately 43% increase in gas distribution rates above and beyond what residential heating customers are paying for now. I believe that's the residential calculation specifically. And from our calculations, 40% of that request was driven by an increase in pre-tax profits. Our calculation, as cited in our brief, was that this reflected a requested 101% increase in profit as compared to pre-tax equity return. So this is essentially the company's shareholders seeking a huge raise at a time when utility affordability in Connecticut has reached a historic low. So it's very appropriate for my office to advocate for cuts to this revenue increase and for the authority to carefully consider all areas that can reduce the impact to customers from the enormous ask in the application. I'm just going to address a few issues, some of which were raised by Attorney Pace. The first, which I think the authority is probably bored of hearing from us on, is future plant. We do disagree with the company's argument that it has a legal right to recover a return on plant. And, my colleague, Attorney Wheel, discussed this in the UI rate case. And here, where, we think there's an even stronger argument to stick with the bedrock principle that used and useful, that the used and useful standard apply. There is precedent from the authority that utilities may only earn a return on prudently invested capital that is used and useful. The authority found this in the first UI decision, 220808, and in the CNG-SCG, the authority reinforced this position, stating that the inclusion of forecasted incomplete plant deviates from the fundamental principle that rate base should solely reflect prudently invested capital actively serving in the public interest. That was 231102. So as we have acknowledged in the past, the use and useful standard does not prohibit the authority from allowing for contemporaneous recovery. But it does prevent Yankee from asserting that they have a legal right to it, that they're entitled to it. This is in the discretion of the authority. And here, especially in a case where we have concerns about capital planning and aligning with the state's long-term energy policy goals, providing revenue for plant that is not in service simply doesn't make sense. And we have consistently argued that if there are going to be departures from the used and useful standard, it should take place in the context of, on the electric side, it should take place in the context of performance-based rate-making model. There are pathways on that, and that the authority is considering, including, the targeted use of trackers. We have not yet engaged in a PBR analysis or a generic docket on gas here, and we do appreciate the authority's acknowledgement that that is the first initial step to creating a PBR framework for gas companies, is to have a generic docket where we can consider these issues in a whole. We support that, but that would be the place where any deviation from the bedrock principle of used and useful should be considered, not here in this rate case proceeding. And I did want to reiterate that we do support the approach that the authority has taken in the PFD with respect to PBR. PBR isn't even finalized for the electric distribution companies. I know the authority is working hard on a final decision there. We think there's enough unique considerations for the gas industry where you can't just overlay principles that were discussed in the context of the electric distribution world onto the gas company model. So we do think it's important to engage all stakeholders in order to develop a framework for PBR for the gas industry in the same way we've done for the electric. On incentive compensation, we just want to say briefly, we see no difference between the disallowances in this case and the rationale used to uphold disallowances in the Aquarian decision, which we flagged because the company did cite to the broad principles from the recent Supreme Court decision in Aquarian, but did not acknowledge that the court specifically upheld Pura's total disallowance of incentive compensation there. And in fact, we see the rationales very similar between those adopted in Aquarian and here in Yankee. So do not feel there's any reason to deviate from that. We also agree with the PDF's application of deductions on inflation adjustments. So we have raised this issue mostly in the context of the RAMs or PBRs, not in this proceeding, and did support the same position in the UI oral argument last week that Pura's inflation adjustment disallowances made sense. It's not appropriate for a company to apply an inflation adjustment to a full swath of its total O&M expenses without explaining specifically what's driving that inflation for those contexts. I think I'll end there. I do want to conclude by just reiterating again that the Office of Consumer Counsel believes that the company is overstating the issues of bias. We recognize that a proposed final decision is the product of all staff and have faith that a final decision would be free of bias and would withstand judicial scrutiny. We greatly appreciate the efforts of the authority. We also recognize the substantial work that the entire Yankee team has undertaken in this proceeding. Ultimately, our goal is an efficient, fair outcome for consumers, and we look forward to pursuing that path in whatever form takes next. Thank you very much.
Thank you, OCC. Attorney General's office.
Good morning, Commissioners. We have no objections to the draft decision, and the comments I will be providing today will be brief. First, we would like to take a minute to thank the authority, the commissioners, and the staff for their thorough review of the record in this proceeding. We find the motions regarding bias and prejudgment the company has been filing in this proceeding not only a huge distraction, but also an affront to the commissioners and the authority staff who have worked diligently in evaluating this rate request. As the authority is aware, you have posed hundreds of interrogatories, conducted hours of cross-examination, and issued an incredibly thorough draft decision in this docket. The company references errors briefed in the written exceptions in oral argument today. The authority can correct any math errors between now and the final decision. The company also made reference to cuts the authority made in the draft decision. The authority has the discretion to make cuts based on its review of the record. The authority is not bound to only take recommendations made by the parties. The authority has experts on staff who conducted examination and audits and in fact have a responsibility to make cuts where necessary. This is even more important with such an enormous rate request. Yankee has requested $193 million increase that would cause residential customers' bills to rise by over $40 per month. As OCC highlighted, this is the largest requested rate increase by a Connecticut gas company. Let the company appeal. The situations the company raises are extremely hypothetical. The authority should not feel pressured or afraid of an appeal. We have confidence in the authority and the rate-making process. The companies have appealed a number of the PURA's decisions recently, and the court has found in these appeals that the PURA has not exceeded its authority. This distraction by the company pulls away from what matters most and why we are all here today, ensuring that ratepayers are only paying for just and reasonable costs, and that costs arise from prudent and efficient management of the utility. This brings me to my next point, the regulatory risk premium. The Attorney General appreciates the authority's in-depth analysis denying the regulatory risk premium and finding it unjustified. The company failed to meet its burden to demonstrate that a regulatory risk premium of $9.31 million is a just and reasonable cost for ratepayers to bear. The Attorney General urges the authority to keep this denial in the final decision. Lastly, the Attorney General supports the additional cost of capital and operations and maintenance expense adjustments by the authority. As the authority knows, these adjustments will help protect ratepayers from excessive rates. Thank you for your time. If you have any questions, I'm happy to answer them.
No questions. Thank you so much.
Thank you.
EOE?
Good morning, Vice Chair Arconti, and good morning, Commissioner Karen. First, what I'd like to do is thank, obviously, the authority staff for their hard work and consideration in this docket. I'd also like to thank all the parties, the company, OCC, the Attorney General's office, and DEEP for their participation in developing the record in this docket. Just want to say a few things briefly. First thing I wanted to mention in response to Attorney Pace, he made mention, he was talking about the issue of bias, and he referred to motion number 118 in docket 23-1102, the motion ruling there. And he was talking about how this proposed final decision was issued by the presiding officer, and he cited back to that in relation to some of the bias claims. But I wanted to quote from that motion ruling, I think a key piece, which says, consistent with the Uniform Administrative Procedures Act, authority regulations, and longstanding practice, all procedural, evidentiary, and other, and I highlight here, intermediate rulings in a contested proceeding are issued by the presiding officer and are not delegated to the executive secretary. So I think it's fair to say that a proposed final decision is not an intermediate ruling. It's not even required by the Uniform Administrative Procedures Act anyway, as Consumer Counsel Coleman did point out, but certainly would not be the case in any final decision. So I just wanted to note that. Separately, just wanted to briefly say that EOE advocated for a low-income discount rate to be implemented in this proceeding. We still argue that a 10% discount should be developed across all 5 tiers to be built out in this proceeding with a usage cap of 90 CCF. And we would, again, argue for a separate proceeding with all of the LDCs to determine how all the LDCs can build out appropriate separate 5 different tiers for their low-income discount rate. But that concludes my oral arguments this morning. So thank you.
Thank you so much. So we'll enter now round 2, rebuttal. So we'll go back to the company.
Thank you for the arguments offered by counsel on round 1. I'd like to first start with the argument made by Attorney Lopez on behalf of EOE. And he says that if you look at PURA's procedural ruling in docket 23-1102, it doesn't include proposed final decisions. So let's go back to the words he referred to. We cite to this in motion number 108 at pages 30 to 31, and that ruling in docket 23-1102, motion number 118, August 30th, 2025 says, and I quote, all procedural, evidentiary, and other intermediate rulings in a contested case proceeding are issued by the presiding officer and are not delegated to the executive secretary. So let's focus on what's an intermediate ruling. When you look at the first page of this document, it says proposed final decision. So anything short of a final decision is an intermediate ruling. And so our position is, it was very clear from the outset the chair was the presiding officer, and the authority has acknowledged in writing that your practice is everything prior to the final decision is supervised by the presiding officer. That's what the authority says in black and white in that ruling in docket 23-1102. I want to next turn to the comments that were made by the Attorney General's office. And that office points out that in recent appeals, they say, don't be afraid of an appeal. Don't be concerned about an appeal, because their argument is you've been successful in appeals. And I'll concede that on fact-based issues, the authority has been successful in appeals on some rate-making issues. But we're presenting something very different here. And the most principal concern is the issue of bias. And the authority, in all due respect, is not faring well on that issue in the present C&G and SCG rate case appeal. And that's what's caused the Attorney General's office, on behalf of PURA, to offer to C&G and SCG the solution of having a complete do-over and remanding it back to this agency to rerun the hearings and to issue a brand new decision without Chair Gillette being involved. That issue squarely faces us in this case because the chair was the presiding officer and did have a meaningful role in supervising and producing the draft decision. And so the cases being pointed to where the authority received a successful result on some fact-based issue involving core rate making where you're believing one witness over the other, that's legally irrelevant to this issue of bias that's playing out right now in the C&G and SCG rate case appeal. And our hope and our desire is we don't want to have to press that issue, but if we have no choice because there's no consensus resolution, and if we end up getting a decision that's similar to this draft decision, we have no choice but for me to recommend my client's appeal, and they raise the bias issue as claim number one in the appeal that they press. I also want to respond to some points that were made by the Consumer Counsel. And I appreciate the comments that she offered, but she posed the question. She said, isn't there an inconsistency in my position as it relates to how we can meet the requirement of 1619A for a rate review? And what she said was, I'm claiming that the draft decision is tainted by bias, which it is, but I'm also pointing out that there is this significant record. And those are not internally inconsistent. In fact, they make perfect sense. And that's because I agree with her. There's a very substantial record here of credible evidence offered by Yankee Gas over 11 months. That's not been tainted by the chair's bias. What has been tainted by the chair's bias is the 100+ rulings that we had on motions. And what's also been tainted is the draft decision. So that you can rely upon this record that was offered by credible witnesses over 11 months who are subject to cross-examination in an open process to be able to conclude that this record constitutes the rate review that you're required to conduct every 4 years.
Can we just stay on that point? Just sparking a question. I just want to ask it while it's fresh in your mind. So what I'm hearing is the record, the robust record and all the evidence is enough to satisfy the periodic review requirement, potentially if a settlement is presented to the authority. So is the record and all that evidence also not enough for Commissioner Karen and I to issue a final decision on as well, if it's as robust, transparent, et cetera, as you're arguing right now?
I will agree that the record that Yankee Gas has established provides a credible and substantial basis for the authority to issue a decision granting the rate relief that we've asked for. I would agree with that. But the concern that I have is a very practical one, and that is, for the reasons I've outlined, it's very clear to us that the bias has tainted the draft decision in such a significant way, I don't see how you can unscramble the egg and make it right. But that's the concern that we have, and that's why we're recommending a consensus resolution. And I again want to be clear, we understand we have to be balanced. We understand we have to be constructive. We understand we have to balance our needs with those of our customers who have to pay for these bills every month. We understand that, and we prepare to proceed in a constructive and professional way in settlement discussions and present you with something that we think is balanced.
You can continue.
I'd next like to respond to a comment that I heard from both the Consumer Counsel and the Attorney General's office, who said we should be shocked by the amount that Yankee Gas has asked for. But in all due respect, that's not the legal standard. The legal standard under 1619E, A4 and 5 is what amount of revenue does Yankee Gas need to be able to meet its prudently incurred operating expenses and have the opportunity to attract capital to maintain the investments we need to provide safe and reliable service. And we've demonstrated that amount is just and reasonable and it's needed by the company. I also want to talk about the Consumer Counsel's comment on future plant. And what was not talked about is the fact that I spent my time during round one focusing on the plant that actually was used and useful. It was in service. We provided a forecast of that in the original application. While the record was open, we submitted evidence to show that's $37 million of plant that was completed between January 2024 and May 2025 was in service. It was used, useful, and prudently incurred, but yet that was disallowed by the draft decision. There was no response to that in round one because there is no response to that. We've met our burden of proof. No one advocated for a disallowance, but yet the draft decision, without applying a prudent standard, without finding it to be imprudent, give these two manufactured justifications, which I showed are patently false, to disallow $37 million of in-service plant additions that were used and useful. I next want to quickly turn to the Consumer Counsel's comment about incentive compensation. The draft decision disallows 100% of the incentive compensation for not only the officers, but all the men and women who work for Yankee Gas and those who work for the service company that supports them. As the record shows, it's very easy for us to say to our HR department, pay everyone more in their base salaries, but we don't do that. We have below market base salaries for an important reason, and that is to incent employees to strive to do better for the customer and to achieve efficient outcomes. And so incentive compensation is very important to send the right message to employees, which is you have to strive, you have to push yourself, you have to work hard, and if you do well and you achieve your goals, there will be an opportunity. What that discussion did also not highlight, though, is again this inconsistency between the way we're being treated and the way other companies are being treated. My colleague pointed out to me during the break that when you look at the C&G recent rate case decision, they were allowed to recover 50% of non-officer incentive compensation. We read all of your rate case decisions. We study them. We check to see what type of evidence companies submitted and what issues you looked at. When we sit down and we put our case together, we say C&G and SCG provided that type of evidence, the authority had these types of concerns, and we make sure that we can present you with credible information to demonstrate if you're comfortable granting it to them, you should be comfortable granting it to us. But yet we provide that evidence, we produce credible witnesses, and we get a result that's very different than theirs. And there's no justification to explain that other than we have to fall back to, is there some type of predetermined outcome or number that the staff is being directed to work towards? That's the only conclusion we can draw. And the last point I'd like to make is Consumer Counsel Coleman addressed the topic of inflation. Where we can, and I'll use, for example, contracts with our unions, where a contract, for example, stipulates we've already contractually agreed to offer the men and women who work for our unions a labor increase of 3%, we identify that. But there are some situations in running the business where we can't point to a contract to say it will be going up. But we all know, based on the research that we've done and the evidence we put in the record, we do face cost pressures. And so our approach is to say, isn't it reasonable to conclude you can use some type of objective standardized benchmark to allow for a reasonable inflation adjustment for other costs of running the business? That's not all of our O&M expenses, but it is a subset. And we offer justification for that. So I want to once again thank you for the opportunity to present the arguments today. I'm happy to take any final questions if you have them for me.
None at this time. Thank you.
And Vice Chairman Arconti, there was one final point I'd like to make, and that is when the parties have said, we think that this record is not enough to satisfy the review and investigation requirement under 1619A1, not one attorney said during round one what else you can possibly do if you had to open a review and investigation. That's because there is nothing else for the authority to look at. You've looked at the company's books and records. You had the on-site audits. You had exhaustive hearings and discovery. And what I would submit to you is there's no need to do a further review or investigation because you've done that in the docket. And therefore, we can credibly say that we checked the box, we met the requirement for the review and investigation that's required every 4 years by 1619A1. I would challenge the other parties to identify what else you would do if you were to open such a docket, because they're saying it hasn't been done here in this docket. Thank you, Vice Chairman.
Thank you. OCC?
Thank you, Commissioner. Just very briefly, while we are not conceding any bias here, we do have complete faith to the extent that there was any in the process, that you, Commissioner Conti and Commissioner Karen, do have the ability to unscramble that egg. So that is how we would answer that question. The record, as has been acknowledged, has been extensive. The record led my team and I to recommend far less than what Yankee proposed for an increase in revenues. So one can disagree with Yankee without being biased and come to a different conclusion than their application proposed. And I'd just throw out for one final consideration, not to make this more complex, but if Yankee wants additional process on this rate application, it's free to waive its statutory deadline to provide the commission with an additional time and process. And we would not oppose that in our office if that were a pathway that the authority wanted to pursue. So thank you. We appreciate that this argument has been extensive and appreciate, again, the work of the authority. And I'd like to thank my team for all of their hard work over the last year in helping develop this record. And ultimately, we do want this work to be utilized to ensure that rates for Yankee customers remain fair and just and reasonable. Thank you.
Thank you, OCC. Attorney General Office.
Just have one brief issue. The issue the company raises on bias has not been determined by the courts. This is being litigated in the court system. We agree with Consumer Counsel that even if it is found that there was bias, you and Commissioner Karen have the ability to unscramble the egg and issue a decision. There was substantial basis for you and Commissioner Karen to issue that final decision. The thousands of interrogatories, days of hearings, oral argument, you and Commissioner Karen are able to issue that final decision in this case. Thank you.
Thank you. EOE.
I would be remiss if I didn't thank my own staff and EOE for their hard work in this case. I thanked everyone else, but I thank my own staff for the hundreds, if not thousands of hours put into this rate case. So thank you.
All right. Thank you, everybody. So I want to take a 20-minute recess. And then hopefully after the recess, can address some of the things we discussed earlier in the hearing. So let's reconvene at 11 a.m. Yeah, 11. Thanks. All right, let's go back on the record. All right, so Commissioner Karen and I had a chance to confer. So our preliminary assessment is that 16-19 JJ does not bar a settlement in this proceeding. And it would appear to satisfy the requirement for a periodic review. So we're going to encourage parties to continue to discuss and submit a filing with a schedule for submitting a settlement. Okay. All right. So with that, I'd like to end today's oral argument hearing. So I just want to tell everyone how much I appreciate everyone's hard work that's gone into this proceeding over the last however many months, peer staff and all of the parties' work. As noted today by all parties, the record is substantial. So again, thank you for everyone's hard work and have a nice day. Thanks.